Hi, everyone. Welcome to the fourth session of the NYU webinars entitled Contract Law for Arbitrators, Brazilian Law, New York Law, and Transnational Law. Our topic of today is penalty clause. To debate such a relevant issue, it is my pleasure to introduce you Juliana Krueger Pela, my colleague and professor at the University of São Paulo, who, after working for 22 years in a prestigious Brazilian law firm, has recently opened her own firm in São Paulo, Brazil, named Krueger Pela Advogados. Professor Krueger Pela frequently serves as an arbitrator in commercial disputes in Brazil, and we all wish her the best of luck in her new law firm. I also have alongside with me Elliot Friedman, partner of Freshfields Brookhouse Dedinger LLP. He's a top lawyer based in New York and advises companies in commercial and investment treaty disputes around the world. Mr. Friedman has handled arbitration proceedings before almost every major arbitral institution, and he has been kind enough to accept our invitation to share his expertise with us all today. As always, we are in the good company of Franco Ferrari, with whom I have the honor to organize this series of webinars, kindly hosted by the Center for Transnational Litigation, Arbitration, and Commercial Law of the New York University, with the support of the Arbitration Channel, which is broadcasting this session. The Arbitration Channel, as you already may know, will keep all of our 4 sessions available in its YouTube page for anyone interested in the topics that we have discussed so far. Once again, I would like to remind our qualified audience that our speakers will be happy to take any questions during this session. To ask a question to any of them, you may simply use the chat mode whenever you wish to do so. Before giving the floor to our first speaker, which will be Juliana, I would like to share some introductory remarks regarding penalty clause, with the permission and the patience of my distinguished colleagues. As we have seen in our previous sessions, Brazilian law, New York law, and transnational law, namely the CISG and UNIDROIT Principles, they share a common characteristic, as they all consider freedom of contract as a founding principle of contract law. Accordingly, in principle, there is no room to discuss the clauses agreed upon by the parties. The bargain is what it is, irrespective of the gain and losses that will eventually rise from the agreement. That means that, as a rule, contracts must be fulfilled, contracts must be performed, regardless of how harsh such performance will eventually become from the perspective of one or even of both parties. However, even having freedom as contract as a fundamental principle, not all clauses are the same under the eyes of the law. For different reasons, some clauses are considered problematic, and as such, they deserve closer attention. Comparing to the generality of the clauses, the law, so to speak, is less sympathetic to them and exercises some sort of control of its content. This is the case, for example, of the non-competition clause, of the forfeiture clause, and most certainly of the penalty clause. From the outset, it must be noted that both civil law and common law jurisdictions do not consider that the general rules of contract law suffice to deal with penalty clauses. Instead, they both provide a special set of rules specifically to deal with penalty clauses, aiming at, in essence, to limit party autonomy in this field. Although having a similar scope, the methods adopted by civil law and common law to handle with penalty clauses appear to be strikingly different. As a matter of fact, the very concept of penalty clauses seems to be different from the perspective of civil law on one hand and common law on the other. In civil law countries, It is said that penalty clauses could be used not only to estimate damages in the event of non-performance or breach of contract, but also to punish the debtor who does not fulfill his or her obligations. The acceptance of this broad use of penalty clause is counterbalanced with the power that is usually granted to courts and arbitrators alike to reduce the amount of the penalty clause agreed to by the parties. As an illustration, there are rules in this sense in the civil codes of France, Germany, Italy, Netherlands, and Spain in Europe, and in Argentina, Chile, Peru, and Mexico in America. Conversely, in common law countries, it is said that penalty clauses could only be used to estimate damages, but not to punish the debtor in the event of non-performance of breach of contract. The so-called punitive function of the penalty clause is considered against public policy in common law. That means that a clause providing for a penalty would not be enforceable under common law. However, in case the parties agree to liquidate damages, nor the courts nor arbitrators are allowed to reduce the amount agreed upon by the parties. In this case, party autonomy must prevail, with no exception. The different approaches of civil law and common law in the realm of the penalty clauses repercusses in international law. Having both of the alternatives before their eyes, the framers of the CISG apparently have chosen to adopt neither of them. Instead, it appears they have decided to leave penalty clauses outside of the convention, which regulates neither liquidated damages nor penalty clauses stricto sensu. Quite differently, the UNIDROIT principles seem to be closer to the civil law approach because they accept penalty clauses but limit party autonomy by allowing the reduction of the stipulated sum under certain circumstances. It must be noted, however, that the UNIDROIT principles are somehow vague regarding the scope of penalty clauses because they do not clearly accept the punitive function, as some civil law jurisdictions do. Considering how frequent penalty clauses are in international trade, such differences are remarkable and of the utmost importance. Indeed, penalty clauses may appear in almost every sort of contract. Specifically, in the domain of commercial contracts, experience reveals that penalty clauses are quite frequent in construction contracts, in services contracts, in supply contracts, in loan contracts, M&A contracts, financial contracts, and so on and so forth. Penalty clauses are drafted in a variety of ways, and due to their relevance, they usually are carefully considered and negotiated by the parties before being incorporated in their contract. Given its frequency and the differences of the applicable rules, penalty clause is a topic of great interest in the field of contract law today. Therefore, it is with great pleasure that I say that we have three experts with us whose knowledge and experience will help us to better understand the limits of private autonomy regarding penalty clauses from the perspective of Brazilian law, New York law, and transnational law. As previously mentioned, I would like to start with Juliana.
Thank you, Cristiano.
Thank you very much for accepting our invitation to join this webinar. And my first question goes to you, and it regards the functions of penalty clause under Brazilian law. Some civil law jurisdictions are expressed on these matters, saying that penalty clause could perform both the function of estimate damages and to punish the debtor. Do you understand that Brazilian law allows penalty clauses in not only to estimate damages in the event of non-performance or breach of contract, but also to punish the debtor in these circumstances? Juliana, thank you again. The floor is yours.
Well, thank you. I am the one who should thank you, not only for this invitation to join the seminar. I have followed with great interest the previous sessions, but also for your kind introduction about my career. Thank you very much, Cristiano. I also would like to greet and thank Franco Ferrari and Elliot for their participation in this session. I'm very glad to meet you here. Well, before answering your question, I would like to make one brief comment on what you have just said, because in comparison between civil law and common law, Professora Mariana Pargendler considers that in contract law, penalty clauses is one of the areas where there is a marked contrast between two traditions or families. Mariana studies the comparison and she concludes that, broadly speaking, says Pargendler, civil law countries allow the so-called punitive penalty clause, and common law countries deem it unenforceable. The difference could be perceived as unexpected for a distant observer because by prohibiting punitive penalty clauses, common law countries make an exception to the principle of freedom of contract that cannot be found in civil law countries. One could conclude then that the freedom of contract has a broader application in civil law jurisdictions with respect to penalty clauses. However, as Pargendler also notes in her paper, this is not always true because civil law jurisdictions impose several limitations to penalty clauses agreements. And I think, Cristiano, that Brazil is a good or a bad, we will conclude about that later, example of this ambiguous situation. I think Brazil has a proper view on that. So that being said, I am in position to answer your question directly. Just remind the audience which was the question. Cristiano has asked me if Brazilian law allows penalty clauses aiming not only to estimate the damages in the event of non-performance or breach of the contract, the so-called compensatory function of penalty clauses, but also to punish the debtor by stipulating a sum that exceeds the damage, so the so-called punitive function, and that in some cases can be collected even in addition to actual compensatory damages. So this definition will guide us. So in short, Cristiano's inquiry is, does Brazilian law allow punitive penalty clauses additional to compensatory indemnifications? Unfortunately and surprisingly, my only answer is I cannot give you a clear-cut yes or no on this problem, because this problem remains unresolved in Brazil until now. There is a major controversy among Brazilian scholars on this subject, and our tribunals still don't offer a clear and safe guidance on it. So, according to certain scholars, such as Otávio Luiz Rodrigues Jr., the punitive function should be deemed inconsistent with contract law, which, as a fundamental rule, forbids not only the stipulation of private penalties, but also, and above all, its cumulation to the amount of the obligation. For others, such as Judith Martins Costa, the parties are completely free to stipulate clauses with either a compensatory function or a punitive function. She even qualifies the opposing agreement as old prejudice and considers that the admission of a punitive function protects and strengthens the pacta sunt servanda principle, especially when business-to-business agreements are concerned. In my opinion, one of the causes of this debate is the provision of Article 412 of Brazilian Civil Code. It states, the value of the sanction imposed in a penalty clause may not exceed the value of the principal obligation. Certain commentators consider that by imposing a limit to the amount stipulated in penalty clauses, this article outlaws the punitive function of the clause. Although the article's wording is not precise, certain scholars consider that such interpretation is not accurate. They argue that, first, the article mentioned value of principal obligation and not damages value, which is different. Second, this provision should apply only to compensatory clauses. It does not apply to punitive clauses that remain, despite this article, allowed under Brazilian law. This debate shows that this Article 412 brings complexity and ambivalence to the interpretation of Brazilian contractual regime. And I should also say that our tribunals have not contributed to solve this ambivalence yet. The Article 412 is commonly mentioned in cases where the penalty clause has a compensatory function. There, it's clearly applied as a limit to compensatory penalty clauses. On the other hand, in cases concerning punitive penalty clauses, this article is, in my opinion, overlooked by the tribunals. It's mentioned in some cases just to justify the prohibition of the clause with a punitive function, but it's not interpreted in depth. As an example, I can bring up a decision of Superior Tribunal of Justice regarding the delay penalties in real estate market. The situation was the following. The constructor did not deliver the building at the term, and the agreement provided for delay penalty clause. The discussion was, can the victim requires the penalty plus indemnification plus the delivery of the building? The decision taken by majority of votes, there was a debate, simply mentioned that, and I'm quoting, coherently with modern legislation in comparative law and with the solely compensatory function of a delay penalty clause, the Article 412 avoids the unjust enrichment of the victim, limiting the penalty to the principal obligation. And it was all about Article 412. In my opinion, this is not a real interpretation of Article 412. It does not even clarify the sense of principal obligation. And Cristiano, in my opinion, we in Brazil should seriously think about reformulating Article 412 of Brazilian Civil Code in order to answer more directly your question at first.
Well, of course, it poses several questions the way our civil code is drafted. If you compare a civil code with the German civil code in articles, I think, in paragraphs actually, 340 and 341, it specifically says that you can have punitive function or liquidate damages function. So for a German lawyer, it would be quite easy to answer the same question. But less interesting, I must add. I have a follow-up question regarding this. Despite this debate among scholars and courts alike, in your experience, do you think that the parties refrain from stipulating clauses with punitive function in Brazilian contractual practice, or do you think that such clauses are frequent among us?
I would say that it's very frequent, especially in business-to-business contracts. They don't refrain based on that interpretation, which leads a lot of questions to the judge or to the arbitrators.
So it's not a theoretical question. It's quite a problem that we have to deal with. It's interesting because sometimes we say in Brazil that our clauses are the way they are because of international practice, and sometimes because they should, for some reason, come from New York. And that's probably not the case of penalty clause. We'll see when we ask Elliot some questions. But in my experience, it's the same as yours, in the sense that penalty clauses aiming at to punish the debtor are are quite frequent, and they sometimes I think the drafters were a bit shy to write in that. And more recently, they're very clear on that. So you have to say that if this is a forbidden clause, then that's the end of the story. Otherwise, you must enforce it. So it's a very practical question these days. But you already mentioned that civil law countries, and amongst them Brazil, of course, has this perhaps a bit complex approach towards penalty clauses. And we know that Brazilian law, like several other civil codes, also allows the reduction of penalty clauses. Would you be so kind to comment on this? What are the criteria that must be observed? What are the rules concerning the reduction of penalty clause? I think this is a very, very important thing from practical perspective, because it's hard to agree on some, and then you have to consider how likely this agreed sum will be reduced in the event that one of the parties go to the judge or to the arbitrator to ask such a reduction. Please.
Great. So this turn I can give you a more direct answer. So yes, Brazil law allow the judge to or arbitrator to reduce the sum agreed by the parties, and it's expressly provided in Article 412, the following 413, the following article of Brazilian Civil Code. It says a penalty must be I would register. Stress that point. A penalty must be reduced by the judge on an equitable basis if the principal obligation has been performed in part, or if the amount of the penalty is manifestly excessive, considering the nature and purpose of the transaction. So this article gives to the judge or arbitrator strong power to interfere in parties' agreement. Doctrine considers that parties cannot deviate from this rule, so cannot agree on the contrary in the contract. Well, first, the rule says on an equitable basis, and it means that the reduction must be reasonable and proportionate. Second, the article imposes two alternative conditions for the reduction. First, the principal obligation has been performed in part. So this is the first condition. Or the amount of the penalty is manifestly excessive, considering the nature and the purpose of the transaction. I will comment each one separately because they are different conditions. The first condition, partial performance of the obligation, is taken obviously under the premise that the performance is still useful for the creditor. Well, it justifies the reduction of the amount because the creditor has already benefited from the performance. So the rationale of the article is if the penalty clause functions as a compensation or a or even a punishment to the debtor, the partial performance of the obligation mitigates the need of compensation or reduces the incentive to perform. So it can be reduced. The other condition, amount of the penalty is manifestly excessive, focus on abusive or unreasonable penalty clauses. Well, and it's interpreted as following. The amount must be excessive considering the nature and the purpose of the transaction. Well, to define the nature and the purpose of the transaction, especially in business contracts, the judge or arbitrator must evaluate the economic function of the transaction and the parameters of the market where it occurs. But it's not easy, as we can see later if we discuss case law. And I would like for now to make just one final remark to link this question to the prior one, Cristiano. The articles mentions the transaction itself as a criteria to evaluate the amount and not the damages. So by saying the transaction and not the damages, for many authors, that article 413 reinforces the argument that the Brazilian Civil Code accepts punitive penalty clauses. But we can discuss later case law if you want. Thank you.
Well, perhaps we'll come back to that, but perhaps one of the major issues that the Civil Code asks us to consider the transaction itself, and penalty clauses are part of the transaction, have been negotiating the whole balance that eventually was defined by the parties. So we'll come back to that, but there was a lot of enthusiasm with this rule. The second part, it was introduced by the Civil Code of 2002, but it's a bit complicated to apply such a rule. We'll come back to that, but I'd like to learn about more common law. I was perhaps dared to make some introductory remarks about common law. I hope I was not entirely mistaken, but I'd like to check if what I said was not entirely wrong with Elliot. Elliot, I would like to ask you if it is a precise statement to say that to punish the debtor in the event of non-compliance or breach of contract through a penalty clause, it is actually forbidden under New York law. And I'm a bit curious about that, because we all are used to say that New York law is very protective of party autonomy. And I think it is also safe to say that penalty clauses, stricto sensu, they're quite frequent in international trade, so it's not a very odd provision. Despite that, they seem to find no love under New York law. Is that correct? And if the answer is in the positive, why is it so? What are the grounds in which such decision from New York law is supported? Would you be so kind to enlighten us about this issue? Thank you again for accepting our invitation.
Thanks very much, Cristiano. It's a pleasure to be here. Thanks for having me. It is also a little surprising to me that Brazilian law protects party autonomy more than New York law, at least according to some commentators, as Juliana explained. But yes, you're correct. Penalty clauses are forbidden under New York law, but it is not as simple as that. It never is, and the devil is always in the detail. The starting point, though, still remains one of party autonomy. New York courts, as one would expect, hesitate to interfere with party agreement. The leading text on contract law, which is Farnsworth, puts it as follows, and I quote, "It has become increasingly difficult to justify the peculiar historical distinction between liquidated damages and penalties. Today, the trend favors freedom of contract through the enforcement of stipulated damages provisions, as long as they do not clearly disregard the principle of compensation." So where does that leave us? The initial presumption under New York law is that your liquidated damages provision will be enforced. But you can then show that the provision is actually an unenforceable penalty because it disregards the principle of compensation, because it is unlinked from the nature of a compensatory remedy. So what drives the analysis? A liquidated damages clause under New York law has to satisfy two elements to pass muster. The first is that it must represent a reasonable measure of anticipated harm. And the second is that the anticipated loss must be difficult at the time the contract is executed to estimate. So a liquidated damages clause that satisfies this two-part test is fine, but a clause that fails it is a penalty and won't be enforced under New York law. Now, in practice, it's usually the first prong I mentioned that gives rise to most disputes, which is the requirement that the clause must reflect a reasonable estimation of harm. And here the key test, like in so many other areas of law, is one of proportionality. The liquidated sum must bear a reasonable proportion to the probable loss. If it does, it's fine. But if the fixed amount is, and I quote from the New York Court of Appeals, plainly or grossly disproportionate to the probable loss, then the provision is a penalty and it won't be enforced. So here we start to see a strong line of difference between at least some commentators in Brazil and New York law on the compensatory versus punitive nature of these clauses. So if I return to the question that you began with, Cristiano, the point here is that New York law has a deep respect for party agreement, of course, but against the policy backdrop that a liquidated damages clause that is disproportionate to probable loss is against public policy because it has an interorum effect. It secures contractual performance by making the consequences of a breach wildly disproportionate to the harm actually caused by the breach. And that's not a situation that New York law wants to endorse as a matter of public policy, even if the parties have agreed to it at the outset of their relationship. Now, there are many, many nuances in differentiating between permissible and impermissible clauses, but I will pause there, Cristiano, because I've no doubt that you have follow-up questions.
Yes, I certainly do. It's quite interesting, this topic, and very useful also. Because speaking from our experience in Brazil, it's not quite easy, even if Brazilian law allows that some commentators, I'm under this opinion as well, a punitive function of the penalty clause, in the absence of clear wording in the contract, it's not easy to differentiate those functions. And some commentators here, this is the traditional position also, is that penalty clauses, they play both roles. They're at the same time encouraging the debtor to fulfill its obligation, his or her obligation, through this tailoring effect, but also compensating damages. This is a position that I'm not very enthusiastic, but it's very traditional. A lot of authors, they say so. But if you understand, which seems correct under my perspective, you have different types of penalty clauses. To differentiate such clauses, it's not an easy task. I'll give you an example from my practice. If we think about a penalty clause that is linked to non-competition clause, because sometimes it's quite obvious. If you have the penalty clause and a share purchase agreement of some merchandise, you can sort of estimate the possible damages. But if you think about competition clause, that's not a value in itself. Sometimes you only resort to the value of the clause, of the non-competition clause, by considering the penalty clause, saying that if you disrespect that, you must pay a determined sum of dollars. And in case like this, how hard, so to speak, is to thinking about from the perspective of the party that is challenging the penalty clause. How high is the threshold in order to say, no, this is not an estimated damages clause. This is, on the contrary, this is a penalty clause and thus unenforceable under New York law. Is it very hard to demonstrate that, or somehow the courts are more open to consider, no, this is not reasonable under the circumstances? I understand that you said that grossly deviates from the estimated sum. So there's some room where you can make an argument in one way or the other. So what I was trying to understand is how complicated is to challenge this type of clause. Let me give you an example that I think it's a very frequent example. Those clauses are usually combined with penalty clauses. Is it too complicated to challenge this type of clause under New York law, or do you have instead a lot of room to say, no, this is not a compensation, this is a penalty and that's unenforceable? I'd like to hear a bit more from you, Elliot, if you.
Of course, thanks, Cristiano. It's that line that separates the permissible from the impermissible. It's not easy to draw in the abstract. It often turns on questions of proportionality, as I mentioned earlier, which is a fairly nebulous concept. You're not going to get bright line rules whenever you're in the world of proportionality here or elsewhere. But courts will often ask a fundamental question, which is this: does the clause reflect a genuine estimate of the likely harm that would be caused by a breach? Okay. Or does it bear no reflection to the likely loss and instead seek to compel performance and to punish breach? Not okay. It's always going to be a factually dependent calculation, but there are helpfully a couple of guideposts in the analysis which we frequently see out of the courts. I'll mention three of them pretty briefly. The first is the question of timing. When is the proportionality test applied? When do we decide whether the clause is a reasonable estimate of harm or is disproportionate? And the answer is generally at the time of contracting. Some courts have taken a different approach in specific cases, but many courts will ask whether the liquidated damages clause reflected a reasonable estimate of harm at the time the parties entered into the agreement. But this can lead to strange results, at least in my view. Let's say at the time of contracting, your non-competition clause, Cristiano, let's say the parties thought that their venture would be wildly successful and that a breach would undermine that huge success. So they agreed an enormous liquidated damages provision. Fast forward 5 years, the venture has not been a success. It has not got off the ground. It is close to a failure, though the parties are still trying. One side then breaches. That side is hit with the huge liquidated damages clause under a liquidated damages claim under a clause that felt proportionate at the time the parties started out, but which is massively disproportionate now. If we are strict about it, if we apply the rule strictly that proportionality is measured at the time of contracting, then this liquidated damages clause might be okay, even though it's out of all proportionality today. But to many, that doesn't feel right, which is why courts sometimes look to other principles to assist with the analysis. Which brings me to the second point. Another question often asked by courts is whether the provision is tailored to the anticipated loss. There are many ways to breach a contract. Some are serious, others are minor, and there are many different effects of contractual breach. Some cause the innocent party no harm at all or minimal harm. Some cause the innocent party significant harm. If the liquidated damages clause provides for the same damages regardless of the degree of breach or regardless of the effects of that breach, then there's a real risk that it will be deemed an impermissible penalty. If the clause requires me to pay you $1 million a day regardless of the severity of my breach, it may well be found to be insufficiently tailored to the expected harm. Now, liquidated damages clauses don't have to be perfectly tailored to the different types of breach. No one is expecting prescience when you enter into a contract. But at the same time, these clauses can't be a blunt instrument that pays no regard at all to the realities. Because if the clause is that blunt instrument, if it applies a huge penalty regardless of the breach, then it will likely fail the proportionality test, at least with respect to breaches that are minor. So we come back once again to the proportionality analysis. And then finally, point 3, which is linked to points 1 and 2, also returns to proportionality. If the liquidated damages clause gives rise to a huge windfall for the innocent party, it's going to be viewed with a skeptical eye. And that's because a windfall will take the clause out of its intended function, which is to compensate in an efficient way, and instead move it into the world of compelling performance by threatening huge damages for even the most minor breach. So my advice to those drafting these clauses, trying to figure out, is this one going to be okay or is this one going to be struck down, is to try to tie the clause to some sort of formula or mechanism that varies with the timing of the breach or the extent of the breach or the effects of the breach. Now that's, of course, Easier said than done, but the more tailored your clause and the less of a blunt instrument it is, the more likely it's going to be upheld. Cristiano, I hope I have answered your question.
You certainly have. It's a completely answer to my question. And it connects to my experience as well. Because I said that penalty clauses are negotiated and sometimes they're tailor-made, but that's only part of the story. Because perhaps less often than before, but we also have seen penalty clauses are quite general and quite harsh. And then those clauses raise exactly the type of question that I just mentioned. Because you have a minor breach, and then the other party say, okay, I have this penalty clause, so give me $1 million. It is not, in principle, unenforceable under Brazilian law, but it would certainly be reduced to something proportionate to those kind of non-performance. And the clauses that are usually deemed enforceable and that not reduced are the ones that are better written without surprise. And many times they're quite proportionate from the beginning by saying that if you do not fulfill that within this time of period, then the penalty will be the following. Afterwards, will be reduced to some amount and so on and so forth. So those clauses, they at least seem more proportionate. And I think that's very important to courts and arbitrators alike, because you have this, at least this feeling of that something is wrong when you have no damage or minor non-compliance with the contract, and then you have this huge amount of money to be paid. So I would say that more carefully this clause in particular is written, the better the chances of having it entirely recognized by courts or arbitrators alike. So I think it's different methods, different approaches, but various common traits as well, if we go deeper, if we go beyond the surface. But now I'll come back to that. I have a lot of questions in my mind, but I also want to disturb Franco a bit about international law, because it is expected, Franco, for international law to solve all these issues. You have these problems in the civil law, you have difficulties in common law as well, and then you go to the CISG, and what do we find in the ISG? What is the answer from this problem from the CISG perspective, Franco?
Now, allow me to first refer to the CISG. In this respect, it is, of course, important to note that even though the CISG may apply to a given contract, it may not settle a given matter, as you just mentioned. This is due to the fact that the CISG does actually not constitute an exhaustive body of rules contrary to what has been wrongly stated by a few courts. In fact, for the purpose of determining the CISG's scope of application, and I make a distinction between sphere and scope, the most relevant provision is Article 4, because it identifies both the matters that the CISG is concerned with when stating that, and here I'm quoting actually, this convention governs only the formation of the contract of sale and the rights and obligations of the seller and the buyer arising from such contract, and some of the matters that are excluded from the CISG scope when providing, again expressly, that in particular, except as otherwise expressly provided in this convention, it is not concerned with, and this is relevant, you will see why, A, the validity of the contract or of any of its provisions or of any usage, and B, the effect which the contract may have on the property in the goods sold. Now, as far as the first part of the provision is concerned, it is worth pointing out that despite the wording, the matters listed are not really the only ones that the CISG is concerned with. So there is a problem with the text. Let me give you an example. Article 8 of the CISG sets forth rules relating to the interpretation of any statement or conduct of a party, meaning it addresses an issue that does not relate to any of the matters listed in Article 4 express. Now, similarly, the issue dealt with in Article 11, form requirements, and Article 19, modification of contract, also cannot be qualified as a matter listed in Article 4. Now, it must also be stressed that not all issues relating to those listed in Article 4 as governed by the Convention actually fall within the scope of the Convention. Let me give you an example on this one as well. Now, as far as formation of contract is concerned, for instance, the CISG merely governs the mechanism leading to the conclusion of a contract. In other words, it is concerned solely with the objective requirements for a conclusion of a contract. Now, the issue of whether a contract is validly formed, however, is not subject to the CISG, as can easily be derived actually from Article 4, which I mentioned earlier, except for those issues for which the Convention provides exhaustive rules. And here again, one such rule is Article 11, governing the formal validity, but the formal validity only. What does this mean? This means that issues such as capacity to contract and the consequences of certain vices of consent are left to the applicable domestic law, clearly. Now, as I said before, Article 4 not only lists some of the matters that the CISG is concerned with, but it also contains what courts and scholars clearly consider a non-exhaustive list of matters it is not concerned with, except, of course, where the CISG otherwise expressly deals with issues. And this is important for today's topic. Now, these matters are the validity of the contract or any of its provisions or any usage, as I mentioned, as well as the effect the contract may have on the property in the goods sold. Now, in practice, this means that where a dispute concerns a matter listed either in Article 4a or 4b, and therefore, so to say, apparently is excluded from the CISG scope of application, a court or the adjudicator has to first examine whether the CISG provides a solution to the specific problem. Now, when an issue arises with respect to validity, for example, one has to first look into whether the specific validity issue in dispute is expressly dealt with by the CISG, as is, as I mentioned just now, the formal validity, to just give one example, before resorting to sources of law other than the CISG, meaning extrinsic, non-CISG related sources. But of course, Article 4 is not the only provision relevant for determining the CISG scope of application. Allow me to just at least refer to Article 5, which also is relevant. Why? Because pursuant to this provision, the CISG is not concerned with the liability for death or personal injury caused by the goods to any person. Now, as this provision has been interpreted as covering both injury to the buyer or other persons participating at least indirectly in the contract, and also injury to non-participating third parties, the buyer's claims for pecuniary loss resulting from a claim made against the buyer by its own customers for personal injury caused by the goods is also actually excluded from the CISG's scope of application. Now, why all of this? Because you can gather from my brief remarks that Articles 4 and 5 expressly list a few matters with which the CISG is not concerned. There are many other matters, as I mentioned before, that do fall outside the CISG scope of application. Now, as per case law, and here we get to the gist, as per case law, such matters include the statute of limitations, validity of a choice of court agreement, for example, the validity also of an arbitration agreement, the validity of a retention of title clause, for example, the validity of a settlement agreement, and this is for the purposes of this webinar, of course, most important, the validity of liquidated damages and also penalty clauses. This is constant case law. The CISG does not deal with the validity of these clauses in one way or another, which you actually, Cristiano, have mentioned in your introduction. Rather, their validity is subject to the applicable domestic law. Although, and this is important to point out, the issue of whether these clauses form part of the contract at all, in the sense of whether they have been agreed to, is governed by the CISG's rules on formation, including, importantly, those on the Battle of Forms. Similarly, in my opinion, the interpretation of these clauses are subject to the CISG, specific to Article 8 of the CISG. Now, unlike the CISG, and this you mentioned also, Cristiano, the UNIDROIT Principles, the other instrument I at least want to mention here briefly today, addresses penalty clauses. Article 7.4.13 clearly states in para 1 that where the contract provides that a party who does not perform is to pay a specified sum to the agreed party for such non-performance, the agreed party is indeed entitled to that sum, irrespective of its actual harm. Now, this provision was not only applied by arbitral tribunals, and you find, of course, arbitral case law, but allow me to say it was also expressly relied on, for example, by a Supreme Court, specifically the Polish Supreme Court in a 2003 decision. Now, the Supreme Court held that if the contract provides for payment of a penalty in the case of a non-performance or improper performance of a given obligation, the debtor is not released from paying it, even if it can prove that the creditor has not suffered any damage. So this is a Supreme Court decision which expressly refers actually to 7.4.13. But Article 7.4.13 para 2 states that notwithstanding any agreement to the contrary, and this is something you, Juliana, mentioned earlier, meaning if the parties agree to the UNIDROIT Principles, Article 7.4.13 does not allow them to then opt out of Article 7.4.13 para 2, stating that the specified sum may be reduced to a reasonable amount where it is grossly excessive in relation to the harm resulting from the non-performance and to the other circumstances. So here we clearly see a reference to some of the criteria mentioned by all of you. What does it mean? It means that, in my opinion, this provision allows the decision maker to reduce a penalty. We know it. In a 2015 decision, and I only refer to this decision for reasons you will see right away, because it's peculiar. It is not rendered by arbitral awards, which commonly, of course, apply Article 7.4.13 para 2. But in a 2015 decision, the UK Supreme Court referred to Article 7.4.13, as well as comparable domestic rules, actually. And one justice labeled the rationale behind all of these rules as evidence of, and here I'm quoting, a general convergence of approaches towards a recognition of the utility and desirability of judicial control of disproportionately, excessively, manifestly, or grossly high or unreasonable penalties. Thank you for your attention.
This is quite interesting. It would be a major task for the framers of the CISG to find a common solution by that time, as it is still today. Because I'm speaking from perspective of civil law. If you take a closer look, different civil codes, they appear to be in the same fashion, but the details leads to different solutions in many ways. So if you, for example, if you compare here in America, if you compare the civil code from Chile, which is one of the most important civil codes in our region, it has the rules from 19th century still. So allows reduction in case of partial performance, which is quite widely recognized. But it does not have any rule regarding reduction in case of mere disproportion. If you consider, for example, civil code from Peru, it's already different, and perhaps the latest civil code in our region, which is the civil code from Argentina, it favors perhaps a bit more intervention in the domain of the penalty clause. Now, the problem is that the more legislators allow arbitrators and judges to interfere in the domain of penalty clause, the more complicated it becomes. Because if you think about reduction regarding the mere proportion of the performance of the contract, it's not that complicated. It could be very complicated in a given case, but in several cases, it's a very, very easy decision to make. And I think practitioners are aware of that, because this kind of reduction are very frequently already established in the clause themselves. If, for example, in a lease contract, if you pay half of the amount, you only pay half of the sum in case of non-performance. It's in many cases, I would say, lease agreement cases here in Brazil, so a lot of case law saying that. So this sort of intervention, perhaps a bit shy to modern standards, but safer. And when you allow, for example, as you do in the UNIDROIT Principles, to say, considering the relevant circumstances, then you can at least argue a lot of things in a given case. I'm not saying that it will be persuasive, but the room for discussion is certainly bigger. So considering the wording of the UNIDROIT Principles, it's striking for some perspective to say that you have also a very clear mandatory rule in scholar work to say you only have to adopt the UNIDROIT Principles if you wish to do so. But if you do, you cannot waive this rule in particular. This has caught my attention. Right.
We have talked about this on a different occasion, to remember when we had our good faith session. There as well, the good faith obligation under UNIDROIT principle is a big issue in the sense that it may actually lead to certain obligations not previously expressly referred to in the contract. It may impose obligations of the parties. And if you remember Article 1.7 of the UNIDROIT principles, similarly to Article 7.4.13, expressly states that once the UNIDROIT principles have been chosen, you cannot opt out of the possibility to have your penalty clause reduced or to get out of the obligation of good faith. So this is stunning, because from a contract law perspective, it is incredible. In state courts, I'm not sure this would fly. I say that because in state courts, of course, the UNIDROIT principles can only become a set of rules comparable to all other contractual agreements of the parties, to all other contractual clauses agreed upon by the parties. In arbitration, where the choice of law rules, the conflicts of law rules, may allow the parties to choose rules of law, then it is a little different.
This is interesting. Penalty clauses do not seem to be very popular at all, I would say, but not even in a non-mandatory instrument as the UNIDROIT Principles. They say, okay, you cannot waive the part regarding penalty clause. And if I may, would like to dwell a little bit in the criteria to reduce the penalty clause under the Brazilian law perspective. We have talked about briefly before, but I'd like to discuss right now a bit more from the case law perspective. Because as I was saying, I think that generally speaking, it's easier to reduce the penalty clause in case of partial performance. Not be always easy, but certainly easier. But then you have this broad concept. Say you have to consider the purpose and nature of the contract. Oh, okay, that is understood. But how do you do that in practice? Because at the end of the day, what you have before your eyes is the clause with the agreed sum and someone who's challenging the sum agreed through that clause. So, in our experience, how successful is a claim to defy the validity and, of course, the enforcement of a penalty clause under the second part of 413, which is the newer part? It was, as I said, scholars were very enthusiastic about this possibility when the civil code entered into force. and how popular and how successful, I would ask you, it is in the realm of reality. Let me ask you to share your thoughts on this with us, if you will.
Well, first, I fully agree with you. It's easier and it's much more precise to reduce the penalty clause based on partial performance than on unreasonable amount and excessive amount, as says the 413. Well, we don't have so many cases on application of 413 by our tribunals. And some cases are both applying in the first condition and the second condition. I'll say about that later. But actually, in my experience and researching the decisions, what I found is that to consider the amount unreasonable, tribunals bring other criteria not necessarily included in the legal provision, so nature of the transaction, such as creditor interest, function of the penalty clause, seriousness of the breach, debtor fault, parties bargaining power. So a lot of other criteria that they elect to justify the reduction. We have here in Brazil a recent decision of Superior Tribunal of Justice in which the tribunal has reduced the penalty clause inserted in a sponsorship contract between a food company and the Brazilian Soccer Confederation, the CBF. Well, the company had already paid part of the sponsorship, but the tribunal also considered several other circumstances to reduce the amount of the penalty clause. So applied both conditions of the 412, but for the second one included a lot of other things such as bargaining power and seriousness of the breach and so on. It's very interesting on the other side that in that case, the tribunal openly admitted that the clause had a punitive function. So, but this function was taken into account for the reduction. So the tribunal said, so since it's a punitive clause, it can be reduced more easily. So we are still learning how to apply 413, Cristiano.
That would lead to another question. Why is it so? It's a complicated exercise at the end of the day, because if you allow punitive function, why should it be easier to reduce the clause in this sense? You could simply say, as you do in New York law, for example, this one is forbidden, and it's end of the story. But if you allow it, why would it be easier to reduce in this case compared with the case of estimated damages? I do not follow. And one following question, and I would like to hear Elliot on this perhaps in a moment, is about the role of the damages themselves. Because, of course, if you think about the perspective of the contract when it was agreed by the parties, you could only think about possible damages. But in many cases, what happens is that the validity of the penalty clauses is discussed when the damages, they have already taken place. So the party is able to say that the amount of damages suffered by the innocent party is, well, say 100, and this party who suffered 100 of damages is asking me to pay 1 million. And in some cases, say that there is no damages at all. So, okay, there is this breach of contract or non-performance or improper performance of some clauses, but there are no damages. So, and now I'm asking more a practical question. How persuasive is this argument in a given case? You said, okay, we have agreed this sum, but now the damages, the actual damages, are very unproportionate regarding the sum agreed upon. So this issue has been raised to some extent by Elliot before, but I'm curious to understand how decisive would it be in a given case? Because some, at least speaking from Brazilian law perspective, some scholars say that damages is a criteria, which is a tricky argument because you have agreed on penalty clause, and I'm using it in a broad way, also comprising liquidated damages clause, to not discuss damages. You have established that from beginning, from the outset in our contract. But then if you have to discuss damages, several issues raised. And one of them is the length of the arbitral proceeding itself. Because if you have liquidated damages, you're simply saying, and let's consider liquidated damages, which will perhaps allow us to compare Brazilian law and New York law more closely, because this clause is allowed in both of them. So if you think about liquidated damages, you say, okay, if and let us also think about a clause that is well drafted, saying that in this particular breach of the contract, in this specific case, or the non-fulfillment of this specific obligation, you have to pay that amount of money. And then one of the parties say, I want to discuss damages. This raises several questions, because if you have to discuss the actual damages, that means a much bigger case, at least from time perspective, because as we all know, to calculate damages is something that costs a lot of time, money, and effort. So I want to demonstrate that the damages are actually a lot less than we have stipulated in the penalty clause. How do you see, Juliana? And then I will ask the same question to Elliot. Would you allow the party to, okay, let us see the amount of damages, and then we will think about the reduction, or would you think a Brazilian arbitrator would be very strict to say that's of no importance whatsoever? If you like, you can demonstrate the damages that you think you have suffered, but will not calculate the damages in this arbitral proceeding. I'm talking about years, okay, depending on the damage that we're considering. So could we say, in short, that damages are put outside by the window, but they then will come back by the door? Or should we decidedly say, okay, they're set aside, there's no issue regarding the actual damages in a discussion regarding an stipulated damages clause? What do you think about that?
Well, looking to the case law, I would say that damages come back. Unfortunately, even if it's a penalty clause with punitive function, damages come back when reducing when considering the manifestly excessive value of the clause. So, although I think it's contradictory in our system to look to the damages, I can see that happens. And that, in my opinion, turns urgent for us to rethink our penalty clause regime, Cristiano, because we have a lot of contradictions in the system. And as I mentioned before, and Elliot quoted, it seems that for us, we have a lot of interference on parties' agreement. But we don't have very objective criteria for that. So we try to set damages apart, but then when reducing, it comes as a very appealing argument. Well, how can you accept a penalty clause with a punitive function if the damages are so low? So let's see how we can conciliate that. So it seems to me very contradictory in our system.
I think this is a good issue. I think we have made a good decision by deciding to discuss it, but it's a lot more complex than one may think from the outset. Elliot, as I said, I would like to hear you about that. Do you manage to put aside damages at all, actual damages, in New York law, or are those damages as stubborn as they are in Brazilian law?
I think it's somewhere in the middle. The first main challenge is, of course, the principle of freedom of contract. Parties are generally held to their bargains, so at least an initial presumption is going to be you're held to this clause and you can't bring damages back in through the back door. Another challenge to overcome, which you foreshadowed, Cristiano, is the efficiency role played by liquidated damages clauses, which New York courts are very attuned to ensuring that New York law provides efficient contracting rules. But liquidated damages clause play a very important efficiency function. As you noted, we've all been involved in cases where liability issues are pretty straightforward, and then you spend all of your time and all of your energy debating very, very complicated damages questions. The liquidated damages provision is intended to give us an efficient path through this, if it is, of course, linked to compensation and not deterrence. But this is where I find the approach in Brazil and in many other places that you mentioned quite interesting. If a court or a tribunal is able to modify the penalty clause, then it sounds like in practice that is going to rather undermine the efficiency role played by these clauses, because, as you and Juliana noted, parties will end up pleading damages in full, if only to show that the penalty is disproportionate and should be reduced by the court or tribunal. So I wonder if that undermines one of the reasons for our agreeing to penalty clauses in the first place. If, as Juliana said, damages always come back, what happened to the efficiency function of a clause like this? I'll leave it there.
This is a very good question at the end of the day. I'm not sure whether they should come back, or from my experience, they come back quite often. But I'm not sure this is the correct answer, but that's what happened in practice. And I would say that most of us, it would be very persuasive argument to say that actual damages are quite lower than the sum that was agreed upon by the parties. And if you compare the solutions, this is a very interesting question, perhaps a hard one to answer, because comparing New York law on one side and Brazilian law on the other side, which one is more protective of party autonomy in particular field of penalty clause? I'm not sure. This is a hard question to answer, because if I understood correctly, under New York law, it's perhaps a bit more straightforward approach, in the sense that if you have liquidate damages, we're not reducing it. If it is liquidate damages, you must pay, end of story. The question is a bit different. Is this a liquidate damages clause, or instead this is a penalty clause? If it is a penalty clause, it's not enforceable in New York law, period. So you are perhaps in a more black and white scenario, in the sense that, is it valid? Then it is enforceable. It's not valid, then you have to follow general rules. Instead, in the realm of civil law countries, you are somehow in an odd position, in the sense that it's in principle enforceable. So the bargain is what it is, freedom of contract, but then it can be reduced. With perhaps it's more unsecure in comparison with common law. Because if you are confident that this is a estimate damages in common law, you're not risking much, I would say. Okay, this is it's reasonable. It does not grossly deviate from the estimate damages that were possible to estimate at the time of the execution of the contract. Then you're safe. Instead, under common law under civil law jurisdictions in general, and in Brazilian law in particular, I'm not sure if you could say that, because if we're not entirely sure about the criteria that must be observed in case of reduction of the penalty clause, and that would probably remain being the case of Brazilian law, given that the terms of the civil code are not very enlightened on this, then there is always at least room to discussion regarding the amount that was agreed upon by the parties. And that is precisely what they do not want when they agreed such clause. So on the surface, you would say, oh, this is more protective to party autonomy. But if you go a bit deeper, then you're not so sure. So I'm the impression that Franco would like to comment that, Franco,
Yes.
you are supposed to solve this problem.
I did not want to solve the problem, and I cannot solve the problem. What I wanted to refer to is an arbitral award in relation to something you just mentioned. So there was a sales contract between a Russian party and a party with place of business in England, which did actually provide that in case of delayed payment of the price, the buyer should pay a penalty in addition to the interest at the LIBOR rate. Now, the arbitral tribunal did ultimately award the interest as agreed upon, meaning using the LIBOR rate, but it rejected the claim for payment of the penalty. And guess what? It did actually refer to the provision I mentioned earlier, 7.413, but para 2, according to which the agreed sum to be paid in case of failure to perform may be reduced if it turns out to be grossly excessive in relation to the harm. So here the arbitral tribunal made it very easy for itself and decided that no, LIBOR rate interest is perfectly fine, but we reduce it to it being the penalty to 0. So that's also something that I'm not sure is in the spirit of the provision itself, meaning 7.14.13 para 2. It is an arbitral award from 2001 by the International Arbitration Court of the Chamber of Commerce and Industry of the Russian Federation. But here, the arbitrators, in my opinion, made life a little too easy for themselves by saying reduction means we take it out altogether. That's not the way to go either, in my opinion.
There's this kind of discussion here as well. Reduction is not the elimination of the penalty clause. But then again, if you want to reduce the penalty clause instead of declaring void, that would be the solution of a penalty clause, so to speak, in New York law. If you choose to reduce the penalty clause, then you leave the judges and arbitrators with the problem. It's how to reduce it. And one thing that I think it's quite important in this field is that you have to demonstrate this very carefully. And I would say that we do not see that often, at least among us here in Brazil, because you cannot disregard that even though penalty clauses are subject to a strict control by Brazilian law and several other civil codes and also by New York law, the principle remains freedom of contract. So if you want to go against a given clause, you have to demonstrate why such a clause is invalid or why it should be reduced. So I think it's a good criteria to decide that you do not demonstrate that the relevant criteria are met in this case. You should I think particular thought should be not considered lightly by practitioners, because from the outset, the party asking the fulfillment of the clause is the party that is correct. Mainly if you consider that under Brazilian law, you also allow punitive function. So there will be no room in principle to say that the clause is void. And furthermore, you should comply with the clause as it was agreed upon. But if you want to reduce the clause, it's up to you. It's your burden of proof to demonstrate that such a clause in the given circumstances is excessive, unreasonable, considering the criteria of the civil code, which is sometimes hard to do, but it's your burden of proof. What I have seen in my experience that sometimes parties simply complain about the penalty clause. They do not give many grounds to say that the penalty clause is for some reason illegal. They simply complain that that is a penalty clause, it should be reduced. That's not the way it works. The principle remains being freedom of contract. If you want to reduce a penalty clause, you have to demonstrate why it should be reduced in the given case. And that may be costly, that may be complicated, but that is necessary in order to observe the rules contained in the civil code. They may be complex, perhaps that's not the best decision that could be made under the realm of penalty clauses, but still it's an exception of the principle of freedom of contract and must be considered as such. So I think that sometimes you end up being a discussion that starts with legal rules, and then we also discuss evidence. There is perhaps this difference that's very striking in civil law tradition. I'm not sure about the common law tradition, to say that this is procedural law. It's nothing to do with us. Not exactly. They're connected, of course. You have this distinction in terms of who will study more some issue than other professor. But what has to be demonstrated in each case, this is actually this is necessarily connected with the applicable rules. So it comes, I would say, Professor Ferrari, to the applicable law. you cannot disregard it. You cannot take it lightly. You cannot simply complain that the penalty clause was too high or too heavy. You do not like it. That will not suffice in any system that I know.
Allow me to point to something we have not discussed. And I say that because, as you know, there is actually a decision. There is a decision on this matter by the Court of Justice of the EU from 10th of September 2020. It is the issue of whether one can agree on multiple penalty clauses for the same breach and how that is to be dealt with. But we leave this for a different time.
I'm under the impression that Juliana would like to say something.
Yes, I would only
Please.
add, sorry. I would only add to your comment, Cristiano, that it's especially true in business-to-business contracts, in my view. And I would remember that the German Civil Code excludes the reduction in commercial contracts. So it's very interesting to look this difference also between German Civil Code and Brazilian Civil Code.
Making the life of German lawyers much easier than ours. Again.
In fact, just to add to what Juliana just said, even that decision I just mentioned from September 2020 deals with consumer contracts, and it does not actually deal with B2B contracts. It relates to a directive from '93.
Well, I think we're approaching the time that we have decided to use for this session. I would like to thank you very much, Professor Krueger Pela, for joining us today. It was a pleasure to see you virtually. Pleasure to discuss this topic with you. We have been working with this for quite some time, and it's a challenge from us, but we will get there. We'll get there. We will define the criteria rightfully at some point. And it is also my pleasure to thank Elliot Friedman for joining us today to clarify. I had a lot of doubts regarding New York law. I have still some doubts, but not as many as before. So I have learned a lot today. So thank you for joining us. And thank you especially Franco Ferrari for helping me to organize this, for hosting us. This is a NYU event. And I'm very glad that we're able and capable to do all of our 4 sessions. It was an honor and a pleasure to me to be in this session today and also in the other 3. So thank you, Franco. I'll give you the floor to close the session, to close our series of webinars. Thank you.
So thank you very much, of course, to today's speakers, meaning Juliana and Elliot, of course. I would also like to thank Cristiano. As mentioned on other occasions, it was Cristiano's idea to somehow make sure that the arbitrators who do apply often New York law, of course, and Brazilian law, know what the law is on specific issues, for specific issues in particular, which we identify as being those that have come up and are coming up more and more. The idea is, in order to piggyback on Cristiano's idea, to do these kind of events again at a later point in time in the fall, but with other laws as well. So, for example, English law and Swiss law, which is often identified as the applicable law. We want to also do it with Singapore law and maybe also with Swiss and German law. So again, my thanks to all of you, but to Cristiano for coming up with this idea on Brazilian law, New York law, and transnational law. Thank you, but most importantly, stay safe. Bye.